I'm John Chowning with Campbellsville University for Dialogue on Public Issues. Today I'm pleased to be interviewing a very distinguished guest, Kentucky Supreme Court Justice Debra Lambert. Justice Lambert, welcome back.
Thank you. It's nice to be back.
You've been sitting on the state Supreme Court bench about a year now, I believe.
Almost exactly a year,
well,
yes.
Congratulations. Are you enjoying it?
I am, very much so, and even more than I thought I would.
Mm-hmm. Share just once again a little bit about your background prior to being justice.
Well, I practiced law in a small town called Mount Vernon, Kentucky. You all have several students who've come through here before.
We do.
And practiced law there for about 10 years, then became the first family court judge in our circuit, which was Pulaski, Lincoln, and Rockcastle.
Mm-hmm.
Served in that capacity for about 8 years. And then after losing an election, went back to private practice, thinking I'd never become a judge again and enjoying the private practice.
Right.
But had the opportunity to run for the Court of Appeals, which I did so in 2014. Was successful in that election and served on the Court of Appeals for 4 years. And then Justice Venters from Somerset had been serving on the Kentucky Supreme Court.
Mm-hmm.
Upon his retirement, a vacancy became available, and I felt I was ready to serve the citizens at the Supreme Court level, and I'm happy to do so since January of last year.
Now, why did you were sitting what I would call a safe seat, so to speak. I know that justices and judges are nonpartisan and don't necessarily look at things in a political sense, but generally sitting judges are reelected. So
Yes.
it was a safe seat for the most part. Why did you choose to take a chance and run for the Kentucky Supreme Court from the Court of Appeals?
Well, I felt as though the structure of the Supreme Court was perhaps a little bit better in that at the Court of Appeals level, there are 14 judges elected statewide, 2 from each Supreme Court district. But with that, the panels sit in panels of 3. So there's never an opportunity for everybody to be together. There are fewer oral arguments. So at the Supreme Court level, all 7 justices consider and vote on each case. And it's a more collaborative environment. Plus, the important part is that we also have administrative duties that are different from the Court of Appeals, and that is rulemaking, policy making, budget input to the judicial branch. And so I felt that would be a nice challenge, and it has been so far.
So basically, the Supreme Court oversees the rest of the Court of Justice, as it's called, or a system of justice, the administrative office of the courts, and so on.
Yes. Chief Justice John Minton from Bowling Green is our Chief Justice, and he's actually the administrative head of our branch of government. But because it is such a large branch, he assigns to the other justices particular areas of work that we might have a little expertise in or unknowingly take in a lot of work. But I have worked this past year on reworking our family court rules, which, as I indicated, I was a family court judge for about 8 years, and the first family court judge to move up to the level of Supreme Court. So I get those kinds of questions a lot, and was happy to work with other lawyers and judges throughout the state on revamping our family court rules.
Okay. Now you represent, I believe, the 3rd Judicial or Supreme Court District of Kentucky.
Yes.
Rather expansive area.
27 counties, the largest number of counties in our districts, but they're meant to be approximately equal population. Of course, the Jefferson County area is its own district and is a larger population than the 6 other districts. But
your area is maybe the most diverse in terms of geography of the state judicial districts.
Yes, it begins in the county where I grew up, which is Bell County. down near Cumberland Gap and,
Right.
the tri-state area.
Mhm.
I grew up there in the mountains, and I hope you can still hear it in my accent because I mean to keep that the rest of my
Sure.
days. And goes diagonally northwest up to Nelson County, from which the newest Court of Appeals judge, Jacqueline Caldwell,
Right.
lives in Nelson County. And then it goes south down to Monroe County on the Tennessee border. And then if you want to crisscross back up to the east, it goes all the way to Estill County near Richmond. So
A broad area of
Very
Kentucky, and
broad.
again, geographically at least, very diverse from the mountains and to this area in Nelson County, culturally somewhat diverse as well.
yes.
In the context of the culture and the history of the area. What is the mission and role of the Kentucky Supreme Court?
Well, the Supreme Court is the court of last resort. We get the last call on what
Okay.
Kentucky law is and the direction that Kentucky law goes. Obviously, we also consider not only just the state constitutional rights of persons, but also their federal constitutional rights.
Okay.
So, if and when we weigh in on federal issues and give our state judicial opinion on a federal issue, then that can obviously be of some concern to the U.S. Supreme Court, and they sometimes correct or redirect us through decisions that they might take on discretionary review.
Would a case in that event, if you did rule or impact a federal issue, would the case go directly from the state Supreme Court to the federal Supreme Court, or would it have to work its way through the federal court system?
A petition for discretionary review can be filed on those issues directly with the U.S. Supreme Court. And in fact, there's one there now that I've written that I understand a motion for discretionary review has been filed and is being considered. And I just learned this week that the Supreme Court has asked the federal government to file a response to the motion for discretionary review because it's a matter of immigration policy
Okay.
that came before us in a family court case.
Okay. Now, how does a case, let's say in Taylor Circuit Court, theoretical case, won't even propose what type of case, how would it make its way to your panel of 7 Supreme Court justices?
Once the trial judge here, either with the assistance of a jury or by bench trial where the judge made the decision, him or herself, the parties have 30 days in which to file a motion for a discretionary review if it's a civil case in the Court of Appeals.
Okay.
And then once it's worked its way through the Court of Appeals, if a party is unsatisfied, then a motion for discretionary review, if it's a civil case, can be filed for the U.S. or for the Kentucky Supreme Court to consider it. Criminal cases are a little different. If, let's say, that case from Taylor Circuit Court was a criminal case in which a criminal defendant received 20 years or more, then that case would automatically come for its first review on the merits to the Kentucky Supreme Court.
Okay. Bypassing the Court of Appeals.
Bypassing the Court of Appeals.
Now, would that be an automatic appeal or discretionary appeal?
It would.
I mean, you wouldn't have to review it.
The criminal defendant would not have to file it.
Okay.
But if they did want it to be reviewed, we would, as a matter of right, is
Okay.
the phrase that's used. As a matter of right, we would take that case, yes.
A capital punishment case is automatically appealed, is that
Yes.
correct? To the state Supreme Court?
Yes. It bypasses the Court of Appeals
Okay.
also.
But it's automatic,
Yeah.
basically?
Yeah, it is.
Okay.
Sometimes criminal defendants who are convicted in a capital case don't really want the case appealed, or they indicate they don't, but it does go, yes.
Okay. Now, what are some of the types of cases that the court would hear? And then how does the process work, the proceedings? Are some cases reviewed strictly on written materials?
Yes.
What's the typical timeline? I'm throwing a lot at you in that one question, but it's all, I think, interrelated.
Well, you might be surprised, and the viewers might be surprised to know how many boxes are transported.
Yeah.
For instance, let's go back to the Taylor County case
Sure.
that's here. There would be written pleadings and responses and discovery, and maybe, pardon me, that pneumonia is still hanging around a little bit, but there might be items that were submitted as evidence, photos, exhibits. Those all get packed up by the local clerk, and that record gets transported, usually by ultimately the judges. I end up with a lot of boxes in my trunk when I come back from Frankfurt, and we haul those up to my office, which my local office is in the Pulaski County Courthouse. And we sometimes sit down on the floor and open up each file and each envelope and consider our case review at that stage.
Okay.
As far as how long it takes a case to be rendered once it's assigned to a justice, I did check with the clerk's office on that, and that's typically a 2 to 5 month period of time. Okay. Different cases have different time frames. A case might be held up on motions that are made by the parties, and there is also some time involved in the consideration stage of whether to take the case.
Okay.
If it's a motion for discretionary review, then there are staff attorneys assigned to those cases, and they write up a recommendation to either grant or deny, and the whole court considers that.
Okay. And at some point you decide whether or not to do hearings. Are there certain cases that are any mandated hearings or automatic hearings, or you how do you go about deciding whether you're going to actually have oral arguments, I guess is the better term?
Right. Surprisingly, it seems that fewer and fewer attorneys are requesting oral arguments. And I don't know why that is. As a practicing attorney, I always requested oral argument, but some do not, perhaps because of cost. Many will say this is a case that can be decided, it's a case on the law, and a case that can be decided easily by the court without oral argument. So most cases are decided without oral argument, but if there's something of particular interest, then our court will vote again to grant oral argument.
Now, my idea of oral arguments are like during the Bevan administration, former Attorney General Bashir making an argument, and then Mr. Pitt, the governor's, Governor Bevan's chief legal counsel, presenting an argument, and then the court making a decision, in a very consequential, constitutional sense of what was being argued in terms of, I guess, the executive authority of the governor in that particular case.
Yes, and those arguments, by the way, are broadcast live on KET nowadays, so that's helpful for the citizens to be able to see that, because I always chuckle and say the parking is terrible at the Capitol unless you have an assigned seat or assigned spot, but we do hear those public policy cases a little more regularly, because those are a little bit more tangled to untangle, if you will, in a 25-page brief or whatever. So it is helpful for us to get a better understanding that way. But we do hear even family law cases at oral argument. Again, sometimes the nuances of a family dispute are a little hard to analyze in a brief. So
how do you separate, or do you separate, particularly in a case like a family issue, a case of that sort? Do your emotions ever get entangled in the course of making a decision?
Well, I would say that most every case we hear is emotionally impactful, certainly to the parties. As a family court trial judge with the parents and the children and the grandparents all standing in front of you, then there is a lot more direct emotion. With many of those issues, great discretion is given to the trial judge. So they make those decisions that are hopefully a good balance of law and reason, but there has to be a little bit of an emotional effect to that. And we mostly, as a judicial branch, deal in trauma. And so there's a little bit of vicarious trauma just in working with those types of cases. There are times when I come home from work, and quite frankly, I have had to deal with criminal cases and view autopsy photos and hear about gunshot wounds and blood spatter. I just want to let that go at the end of the day, and that's an important skill for a judge to have.
I would think so.
Yeah, you have to be able to compartmentalize that a bit in order to do an effective job.
Certainly. Once you've heard the oral arguments, reviewed the written materials, sometimes both on a case, tell us how you go about reaching a decision, you and your colleagues.
Well, that's perhaps the best part of the work, if you ask me, because we leave the courtroom, and immediately behind our courtroom, which is a beautiful courtroom, by the way, in the Capitol, we go back into a rather plain conference room, and we start a discussion, one justice at a time. Our law clerks are in the courtroom or in the conference room with us, but the chief might say, Justice Chowning, you've heard the argument today. What is your position? And you'll give your take on the oral argument and the case and your initial vote. And he goes all around the room until a vote can be decided that, it may be a 4-3 case, or it may be a 3-3, I don't know kind of case. So part of the Chief Justice's duty is to assign that case, and if you are in the majority, he might assign the case to you to write, and then the next time we meet, hopefully you'll have an opinion ready for the court to review and edit, and we'll move forward with rendering our decision that way.
Do you ever convince someone to change their position, their initial reaction or take on the case?
Yes, and what is very interesting at that point, the justices at oral argument only have the piece of the court file that is the briefs, both sides of the briefs. But we do not have the exhibits. We do not have the actual court file that's shown all the pleadings and motions and affidavits. So yes, quite often a justice will take the case to write, and as it's often said, I just couldn't write it that way because when I got into the record, this is what I discovered. And so
there may be a change in the outcome or the rate. Where the votes stand.
Yes.
From the initial sit down to the follow up.
Yes. And we even hear termination of parental rights cases, which are, if you will, the death penalty of parental rights. And those are very, very trying. Recently, we had a particularly difficult one. And typically, the assigned justice will read the record, watch the video record, and make a decision. And the other justices don't typically see that record. In this difficult case, at least 4 justices took the time to view the trial. And that's the type of jurists that we have on our Supreme Court, and I'm very proud and pleased to serve with them.
A collegial atmosphere, from what I can tell.
Yes.
From you and a couple others that I've talked to through the years. I'm sure some strong debating at times, but collegial as compared maybe to the legislative branch at times.
Yes, we are very collegial. We do often agree with one another, but we know we come from different careers, different areas, different interests, and but the good faith of all of us is evident, I believe. and we'll agree with each other the next day or even the next case. But we do expect that if someone has a strong opinion and a well-based opinion, that they voice it. And that creates a better end product and a better opinion for the public.
Is there such a thing as a dissenting opinion or minority opinion within the state Supreme Court?
Yes, and I have been known to write a few dissenting opinions. And what's very pleasing to a justice who writes a dissenting opinion is when you circulate that opinion, you can often shift the entire direction of the court, and the opinion might turn out to be a majority opinion, and you have to rewrite it. And each of us have had to do that.
And in subsequent cases, lawyers, attorneys, and even judges may turn to that dissenting opinion? Is that sometimes done?
Yes, and that's
as
perhaps
a citation that you might make in a dissenting opinion?
Yes, and I suppose at this level, your dissenting opinions from the Supreme Court can be very influential and for future cases.
Right.
Or a dissent might be written on something narrow that, even though it isn't part of the majority opinion, it brings to the attention of the practicing bar and the trial judges, hey, this probably isn't a good idea, and if we do this again, there may be a reversal. So you can kind of gently change policy and procedure by a dissenting opinion.
How many women have been Supreme Court justices in Kentucky, approximately?
I think it's only about 6 or 7, but I don't have that committed to memory. Currently, there are 3 women on the court of 7. So 3 is the maximum number we've had. We've not yet had a 4th. And I always chuckle and say I want to change the men's room location to further down the hall where the women's room location is if we ever get that 4th justice. So
that's the major decision.
That's the major decision, yes.
Has there been any research, this is off topic just a bit, but is there any research in legal theory and study of jurisprudence between the temperament of male jurists and female jurists in the context of outcomes, and any difference in leanings or just outcomes of decisions or anything of that sort?
Not that I'm aware, but that would be very interesting. I guess I've just been so accustomed. My father, growing up in the mountains, my father wanted another boy, and he just always convinced me that I could do anything a boy could do. So I never really gave much thought to the gender part of it. But there may be some studies out there.
Would be of interest.
It would be.
It sounds like a good PhD proposal for a dissertation or something for a political science student or PhD in law or something. Now, tell us the process of selecting Kentucky Supreme Court justices. Obviously, there's an election, but tell us about that process, length of terms, and so on.
Each state has a high court, and each state has a little bit of a different bend, if you will, on how their judges on the highest court are selected. In Kentucky, we are elected from 7 geographical districts. Mine, as we've said, is the 3rd and has 27 counties. But in some states, they're elected statewide or appointed statewide. Here, I believe we have the best system. You know, we always think that ours is the best, perhaps. We run on a nonpartisan ballot. That is, we do not run as a Republican or Democrat, though obviously each of us are registered that way, one or the other. But we are elected for 8-year terms at the Supreme Court level, and Circuit Court level is also 8, and Court of Appeals. District Court is the only exception. Those judges are elected for 4-year periods of time. But I like our particular process. I know that there has been legislation proposed that we run from a partisan standpoint, and I would personally disagree with that. I think that it's important to maintain
that would add
nonpartisanship.
some edge to the process, I think.
Yes.
That's my initial reaction.
We're permitted and free to say what our political registration is, either initially or by being asked by a voter or citizen, and that's perfectly fine.
What are the limitations on a candidate running for the judiciary in Kentucky? Kind of the ethical limitations and parameters. You just said you could state your political party.
In recent years, there's been a lessening of those restrictions, but the critical point is that we not announce our position or standing on any particular area, so that doesn't disqualify us for future cases that might come before us.
If I tried to pin you down on a list of issues, how would you rule? You would probably say no comment.
I would likely say that with a smile, but I would say that. And it's not that we don't all have some personal opinions or beliefs or even biases, but it's important to follow the law and the rules. There are many things that I've had to put my stamp on, if you will, that I personally disagree with, but it's not the law according to Justice Lambert. It's the law, and I have to respect that.
You are bound by what binds you as a sitting judge. Obviously, the law binds you, but define what the law is.
Well, the law is both statute and case law, and also the Constitution of the Commonwealth and the Constitution of the U.S.
So that could get pretty complicated in some areas. Some areas it's very clear, but in many areas there's a lot of gray. I would think.
Yes.
A lot of discretionary interpretation, even.
And even if there's a case that's argued to be on point, lawyers and judges are very skillful at saying, well, yes, this case is that type of case, but it didn't specifically address this issue. So the law is in the details, I suppose.
We're down to under a minute. Is there anything you'd like to leave with our viewers and listeners in terms of the state Supreme Court and the judicial system in general?
Well, over 900,000 cases flow through our court system each year. It's a monumental task to make those flow smoothly and fairly, and I'm certainly honored that the voters saw fit to elect me to this position, and it's very temporary. Thank you very much for the honor and duty.
Kentucky Supreme Court Justice Debra Lambert, thank you so much.
Thank you.
God bless you. Travel safely.
And to you.
And always have open standing invitation to Campbellsville, Taylor County, Campbellsville University, and this show.
Thank you very much,
Thank you very
Doctor.
much. This is John Chowning for Dialogue on Public Issues.